Ken Nachbar, thank you for joining us to talk about the Air Products versus Airgas case for part of the Delaware Oral History Project. This case arose back in late 2009, really, when the CEO of Air Products approached the CEO of Airgas about a possible acquisition. Ultimately, those discussions did not prove fruitful from the Air Products side, and Air Products announced an intention to go hostile with a tender offer and filed litigation in the Delaware Court of Chancery seeking to have an injunction against various defensive measures, most notably a rights plan or a poison pill plan. When did you get involved in the case? Were you involved at the negotiating level early on in late 2009?
I believe we were, sort of just generally, we had a heads up of, what was going on, and we talked about some of the strategies, yes. At least I think so.
Right, and your firm, Morris Nichols Arston Tunnell, joined with Cravath, Swain & Moore in representing Air Products. What was the strategy in the early stages, if you can talk about that, short of going hostile and with litigation? And then what was the trigger point that led your side to go hostile?
Yeah, I wasn't intimately involved. I mean, we'd get, I think, calls from time to time about, what was going on in the general strategy. But, I think like any other situation, the business combination made a lot of sense. I mean, I don't think anybody could doubt that. They were sort of complementary lines of business for sure. And so, there would be synergies and an opportunity for, let me back up. Airgas was an amalgam of small companies, mom and pops that were very successfully rolled up into, a company, but it served, auto shops and small businesses and provide industrial gases. Air Products, on the other hand, served corporate America for the most part. They would have, gas facility at an Exxon plant, and Air Products would actually build a plant at Exxon's plant and, provide very high volume industrial gases, and so they're doing tanker trucks or sort of bespoke plants, whereas Airgas is mostly doing canisters. But obviously the two businesses are complementary, and there is some overlap in the middle. That was the idea. So I think the thought was that let's try to do a friendly deal. Let's see if they're willing to sell.
And at the time, the economy was just in the throes of or just after the Great Recession, and Airgas's stock price had been beaten down. The company was involved in trying to develop and implement a 5-year plan, and they were also developing SAP as part of their strategy. And their position was that they weren't for sale. They wanted to execute their plan. Were the corporate cultures, in your view, different at the two companies?
They were very different, and ultimately, it's very funny because when I was going over to argue sort of one of the last arguments in the case post-trial, I had a car ride, to the courthouse in Georgetown, and a lot of people at Air Products actually didn't want the deal to go through. Upper management did. They thought it was synergistic. They thought it was beneficial. But I think the rank and file at Air Products kind of viewed Airgas as a little bit of the Wild West, a little bit of, we're serving corporate America, they're serving, Vito's auto body shop. And, I got a bunch of stories about, near accidents that Airgas had. This is while I'm going over to the argument, and I finally turned to the general counsel and I said, you're really not doing a lot to psych me up here. And we all laughed, and we made the argument, and it came out the way it came out. But yeah, the cultures were actually quite different.
So if there were to have been a merger, the view of some folks was that this would be a difficult integration.
Yeah, I like I said, I think when you got down to the managerial levels above, you got out of the C-suite at Air Products, there was a fair number of people who thought the deal was a bad idea and would really be problematic.
When the complaint was filed in February of 2010, did you anticipate the significance or the potential significance of the legal issues that were involved?
Well, we've all had in our careers a lot of poison pill cases, right? I mean, lots of people have poison pills and have for a long time. Obviously, if you're doing a hostile offer, one of the things you have to do is you have to challenge the pill. So it wasn't any more significant than any other case. It became more significant because this one actually went the distance. A lot of them, the bidder goes away if they get rebuffed, or more likely they cut a deal and they don't really ultimately get litigated. So, we knew that it had the potential to be an important case, obviously, but so did the last 20 cases challenging pills, all of which got settled or went away. So what made it unique was really the staying power, of Air Products, who pursued this for, I think over a year when all was said and done.
In addition to the complaint that was filed by your client, Air Products, there was stockholder litigation, companion litigation that was filed. Did that affect your ability to litigate the case at all?
No, not really. I mean, we were in the courtroom, and being at counsel table with Randy Barron was, a new experience for me. But we worked together well, and I think came to have mutual respect. And I mean, I'm still friends with Randy. I still, we still talk about it, and it's I guess it was a good bonding experience.
Do those types of cases present challenges where you obviously have a client that has a lot at stake, and you have a stockholder case that's in parallel? Your objective is to make sure that you put on your best case, and you don't want somebody else getting in the way or making a mistake that's tactical. How do you deal with that in those situations?
Yeah, and there were, times with a particular witness where, we would want to emphasize one line of questioning, and maybe the shareholder plaintiffs would want to emphasize something else. But mostly we talked and worked it out. And, I mean, ultimately, we divided the time, and we tried to jawbone each other, like, don't spend too much time on this, really focus here. But at the end of the day, if the plaintiffs, if there's a witness and we have an hour and the plaintiffs have 30 minutes, we all do our best to ask the best questions and make, the best record we can in that time.
Now, after the litigation was filed, there was the announcement of the intervening proxy contest, along with some bylaw proposals that ultimately prevailed. Was that something that was anticipated from the beginning when you launched the hostile offer?
Yes, that was part of the arsenal that we would have. You sort of, you've probably done this in the past, and I'm sure most people who are in this business have. You sort of, do almost like a flow chart or a decision tree. If they do this, our counter move is that. If they do this, our counter move. So, yes, a proxy contest and bylaw amendments were always part of the, potential plan. We hope it wouldn't be necessary, but that's, it's a way to, right, you're trying to get to a deal, hopefully a consensual deal. And, if the other side says, no, we're not for sale, okay, well, we're going to elect people to your board. We're going to have your stockholders tell you that they want the company to be sold. We're going to have them pass bylaw amendments that might make it easier for the company to be sold. Maybe you want to cut a deal now. And so that's always part of the strategy.
An unusual and interesting part of this case is that you had facts developing real time while you're going through the litigation, as opposed to sometimes deal litigation where there's a deal announced and then there's kind of a post-mortem as to whether or not the board fulfilled its fiduciary duties. Here you had real live proxy contest, hostile offer, facts changing on the ground. You had law firms that were both representing the parties as deal counsel, strategic deal counsel, as well as litigation counsel. How did that play out, and did that present challenges?
So there's really two parts to that question, I think. How did the facts changing present challenges, and how did having deal counsel and litigation, and they each presented challenges, and they each presented their own challenges. The biggest fact on the ground was, as you pointed out, we were coming out of a recession. The Airgas stock price had been depressed, and it kept running up. And there were several times when it rose above our offer, and not just necessarily because the market anticipates a bump. They were starting to show better results over time, and so the stock price kept going up as the market kept going up. And I think probably Airgas outperformed the market. They're kind of in a cyclical business, so they had a cyclical recovery. So we were chasing the stock price a lot as the saga unfolded, and that's why the offers kept increasing. But they were never really a blowout, 40% premium or something like that. So that was that challenge. The challenge of deal counsel and litigation counsel was a little bit different, and what happened there was, Cravath served in both capacities, and early on there was a motion for confidentiality, for two-tier confidentiality order. At a hearing that I wasn't at, apparently somebody from Cravath said that they really couldn't separate out the deal team, who would not be able to get highly confidential documents, from the litigation team, who would. They would need everybody to get it. And Chancellor Chandler responded by, okay, if you can't separate it out, that's fine. None of you can see any of the highly confidential documents, which really left Morris Nichols as the only lawyers who could see the highly confidential documents, which obviously are the most important documents in the case. So, at the beginning of the case, I had sort of said that my role in the case would be somewhat limited, because I had another trial that was immediately before Air Products. I had the KFC trial, and we were lead counsel in that, and I was going to have a huge role in that case. And I said I sort of have limited time to deal with the Air Products case, and that was the agreement going in. And then, when Cravath came back from court and said, yeah, guess what? This is kind of your case now. We can't see any highly confidential documents. I was not in a happy place, but I did a very smart thing. I went down the hall and I said to Bill Lafferty, Bill, I got a case I need you to help me with. And he unstintingly did. And so I never could have done it without him.
How did the use of highly confidential materials play out in the use of those documents, whether it's at a hearing or at a deposition? Did that present challenges?
Yeah, I remember the first deposition in the case. Rory Milson took the deposition, and Bill or somebody was there, with all the highly confidential documents. Rory went first. He questioned the witness for like a half hour, said, well, I can't see any of the good documents, so I'm leaving. And, because he had to. I mean, he couldn't sit there while we showed highly confidential documents to the witness. He left after a half hour and the deposition went on. And, obviously that presents challenges.
What about at court hearings? Were there times where you had to clear the courtroom?
There were a few times during the trial when we did. We obviously you try to keep that to a minimum, and I think by the time we got to trial, a lot of the highly confidential stuff wasn't quite as highly confidential. It's just how a deal unfolds. But yeah, as I recall, there were times when the courtroom was cleared.
Let's fast forward to the annual meeting and the proxy vote. Your side had a good result. You had 3 new directors.
Well, we thought we had a good result.
At least
we were very happy at the time.
On September 15th, at the date of the annual meeting, you folks must have been ecstatic.
Yes, absolutely.
All 3 of your nominees were elected. Mr. McCausland was, defeated, but then he was put back on the board. But he was no longer going to be able to serve as chairman. You got the bylaw proposals through, including the annual meeting bylaw that would have advanced the annual meeting for 2011 to January of 2011. So that certainly made your side very happy. What was the mood on your side, and what did you anticipate next, recognizing that there was probably going to be some kind of litigation over the bylaw?
So one thing about this is kind of funny, the January meeting, we had great debates about whether that could be moved up to October of the prior year or November. And I said, look, you can't have the 2012 meeting in 2011. I mean, come on, you can't, there's limits. So that's how January got picked. It was, there were a lot of people who were counseling that we should do it in, December of the prior year or November of the prior year. I never thought that was going to work, and since ultimately January didn't work, a fortiori, November or December wasn't going to work. But we thought we had a shot with January. But more importantly, you think the other side's going to maybe cave and maybe try to cut a deal at that point, right? They just got pretty soundly defeated at the polls. The stockholders, certainly expressed their viewpoint. We put in place a bylaw that said that, we can have the next meeting in January. It's just a couple of months away. At that point, we're going to control the board. I give McCausland and the Wachtell team a lot of credit, because a lot of people would have folded up shop at that point. Sort of the handwriting kind of is on the wall, and we were, I think, obviously at that point, like they do with baseball games now. If you've ever seen them, they have the win probability in real time. So it's the top of the 5th, your team is up 1-0, and you've got a whatever it is 65% chance to win. The other team then scores 5 runs in the bottom of the inning, and suddenly their probability of winning is 89%. Our probability of winning was probably pretty high at that point to anybody objectively looking at it.
You also had a dynamic that we will get to a little bit later on in our discussion, which is at the time of the stockholder meeting, a lot of the stock had moved into the hands of arbitrageurs. So they were, for the most part, you would assume that they were looking for a deal to happen, because if Air Products went away, it was likely that the Airgas stock price was probably going to fall, at least somewhat, for some period of time. That turned out to be a double-edged sword for your side, but did that factor into your analysis going forward?
Well, we certainly knew that stockholders, yes, the arbitrageurs were going to support us, and as more ARBs moved into the stock, our level of support was going to be high because they wanted a deal. I'd point out, as we pointed out to the court at the time, every single share that was sold to an arbitrageur, well, almost every single share, was somebody who made a decision that they didn't want to be in Airgas stock. They made a decision to sell. I mean, some of them maybe had to sell for financial reasons, but the vast majority elected to sell their shares. So, the other side said, oh, well, don't pay attention to the arbitrageurs. They're not real stockholders. Our argument was always, well, they accumulated their position because the, quote, real stockholders didn't want to be in the stock. That's why they sold.
Let's get to the trial at this point. You have you're litigating both the bylaw before the chancellor, and then you have the trial on the pill. What were the important factual issues for you to develop at the trial, and who were the key witnesses from your point of view on establishing that there was not a reasonable threat and that the maintenance of the pill was not a reasonable response to that threat?
Sure. It was very interesting trial on the pill, and I feel like we won the trial and then lost the case on judgment on the pleadings. Why do I say that? Because I think we established in showing that our offer wasn't a threat, that the pill, by the time we got to trial, was both coercive and preclusive. And I think we got, basically admissions on that, and I think the court so found. And then, the ruling was, and that had been the law since Moran, right? That you could have a pill, but I guess coercive and preclusive maybe came later in Unitrend. But in any event, that was the law of Delaware for a long time. We satisfied each element of what we thought was the then existing law, only to be told, yeah, but none of that matters. We're really going to treat tender offers like mergers, and if you don't get board approval, you can't have a tender offer, at least when there's a pill out there. And so it was, it may be an advance in the law, and it may be the result that should have been in place all along, but it was, it was frustrating to feel like we proved the things that under existing law we needed to prove, but not prevail.
One of the facts that came out at the trial, which seemed to influence the chancellor, was that Mr. McGlade and I believe one other person had testified that $65.50, which was the offer price that was on the table at the time, was not the final offer, that there was potentially more there. How do you deal with that issue after the evidentiary record's in and you're getting ready to go and brief post-trial? Because the chancellor obviously was concerned that there's a possibility of getting more for the stockholders. The board said $65.50 was inadequate. How is the judge going to step in and essentially, if he's going to enjoin the pill, you're likely to get a deal at $65.50 with enough people to tender so that Air Products takes over the company?
Yeah, no, obviously that was a bad fact, but, people, I guess they've got to testify honestly, and, that wasn't the best and final price. So it's a tough situation. I guess, I don't know, maybe you could argue that that's an improper question to ask, but, if you object to it, you're kind of implying that there's more there. So you're kind of stuck either way, I think.
You also had an additional problem in that regard because of a document that had been produced inadvertently earlier in discovery.
Yes, thankfully not by my firm, but I was sitting in a deposition and I got a call at the deposition, and I can't remember what the offer was at the time, but basically a document had been produced that stated our reserve price, which was significantly higher than the current offer. Obviously not a helpful fact. And it was interesting how that played out, though, because the other side tried to use that document and basically, I think, maybe move for judgment on the pleadings based on it, or summary judgment or something. They tried to make some very aggressive motion. And the chancellor sort of smacked them, and as I recall, and said that, look, that was obviously an inadvertently produced document. You had an obligation to return it, not to try to use it to win the case at a threshold stage. So I think that one, it might have boomeranged a little bit in the short run, but, the chancellor can't unknow what he knows. So, knowing that our reserve price is more than our offer is obviously a problem. I think we ultimately bid the reserve price before all got said and done in the case.
At the close of trial in the fall, how did you feel coming out of that trial with respect to your prospects of prevailing?
We felt great. I mean, like I said before, under existing law, we had to prove that the offer was not a threat, and that the pill was not reasonable in response if it was a threat, and particularly we would prevail if it was coercive or preclusive. I think we proved all three of those things, and I think the opinion reflects that. I mean, it's very interesting. One of the things that we uncovered for the closing argument, and sort of a theme of the closing argument, was the way the pill jurisprudence isn't the right word. The market justification for the pill had morphed over time, and it's sort of like we're kind of beginning presidential campaign season, and when you're in the primary, you talk to your base, and then when you're in the general election, you kind of come back to the center a little bit. It was like that with the pill a lot. I mean, it waxed and waned. When the pill was first out there, it's like, this is a showstopper. You can't do a takeover because we have this poison pill. And then over time, when the pill came under pressure and people maybe thought it wasn't as good an idea, it's like, oh, no, this is only for two-tier offers, and it's only for coercion. And, if you ever had a fully financed, all shares, same price for everybody, premium offer, and the offer was out there for 6 months or 8 months, and the company had a full chance to communicate, of course a pill would never stand in the way of that offer. And there were lots of articles and quotes, and as I remember, maybe even a video clip from Mr. Lipton to that effect. So we felt like we had checked all the necessary boxes, and we had done at trial what we needed to do.
And then the Airgas took the court's decision on the bylaw, which was decided, I believe, on the last day of trial. They appealed it to the Delaware Supreme Court. You must have felt confident after the chancellor held that you could hold your meeting in January.
We felt great. We didn't know when that ruling was going to come. I remember it very well. I was walking with my wife. She had come down after the trial. We were going to stay for the weekend. We're down at Rehoboth, walking on the boardwalk. I got a message that, there was a decision. I read it. It was in our favor. Yeah, we were all feeling really good at that point.
But you also knew that the Supreme Court had been alerted that there was likely going to be a request for an expedited appeal.
Yeah, we knew an appeal was coming, but, obviously when you win at the trial court and you have a respected judge and you have, what seemed like a well-reasoned opinion, your chances on appeal, it's never certain, obviously, but you feel pretty good about it. And again, that was another moment when we thought they might, cut a deal and try to work out some arrangement where, maybe they got a little bit more money and we got a consensual deal done.
And that didn't happen.
Obviously didn't happen.
When the Delaware Supreme Court reversed on the bylaw issue, was there anything that gave you pause with respect to the pill case?
Not really, no, I don't think so.
I noticed in the Supreme Court's opinion it cites Versada, and at one point it quotes from Versada talking about a pill and the opportunity over 2 elections to remove the board and establish a majority, which was what ultimately this case came down to. Immediately after the appeal, the chancellor requests the parties to provide some answers to some questions and ultimately opens up discovery following the Supreme Court's decision. What was your strategy at that time in light of the chancellor's questions?
Yeah, and I don't remember the specific questions at this point.
Well, the important one was, is this your highest offer that you're going to make?
Right.
He had a number of questions. How do various things reflect the case going forward? But the biggest thing, it may have been the very first one, which was, is this your best and final offer? And ultimately, your side proposed $70
Right.
a share, and that seemed to throw everything into a cocked hat.
Yes, and so, I mean, as I sit back today, I'm not sure that's an appropriate question to be asked, and I'm not criticizing the chancellor in any way. I mean, obviously a terrific jurist, but, when you think about it, should a judge in these circumstances be able to say, is this your highest offer? I don't know. I mean, you could argue both sides of that. But there was some tension at the company about how much to pay and how high to go, and that was a leitmotif that played out throughout the case. We were, like I said, I felt we were always kind of chasing the price a little bit. I have little doubt, had we offered 70 at the beginning of the case, we would have gotten the company. But obviously, a year or a year and a half later, you had a lot more knowledge, right? I mean, the country didn't go back into another recession. We didn't have a double dip, which some people were predicting. Things were on a much better path. So, you could bid 70 at the time of the ultimate decision in this case, because you're just in a different economic environment than you were 12 or 18 months earlier. So, yeah, I mean, obviously a lot of thought went into what was going to happen. There were some at the company who didn't want to go forward at all, didn't want to raise the price and just let's walk away from it, or let's just leave our offer out there and whatever happens, happens. Ultimately, they decided to go to 70, which I think had been the reserve price. And that was the decision.
In the intervening period between the close of the testimony at trial and the Supreme Court's decision on the bylaw, the company, the 3 new directors, or the board unanimously had rejected 6550, and that included the 3 Air Products nominees. That could not have been helpful to your case.
No, that was always a terrible fact. And I mean, look, and again, I give the other side tremendous credit for, just doing a great job with those directors. And, we always talk about independent directors, and there's always a question, are the independent directors really independent? And, there's a wink and a nod, I guess, sometimes, or cynics say, yeah, they're not really independent. Well, we put on people who are independent. That's, we understood that. We did think that they would think that the company should be sold, but the other side, did a great job and with the lawyers and the bankers of explaining their vision for the future, which, by the way, turned out to be correct. I mean, as we all know, the stock price, I don't know where it is today, but in the months and couple of years after the all the legal proceedings, the stock price got up above 100. And so stockholders did well. There's lots of times when people, it's all entrenchment and we're protecting ourselves. Here, they said they were protecting the stockholders. The company had great value, and the subsequent events proved that out. So, I give them tremendous credit. But from our standpoint, yeah, I mean, you put on independent directors, and they can't be accused of entrenchment or bad motives or anything like that. They looked at it objectively. They said that 6550 was inadequate. That was obviously a horrible fact.
Then the price went to 70, and two of the three new directors testified in the supplemental hearing. And the chancellor was candid when we spoke with him that Mr. Clancy's testimony, and also Mr. D'Annunzio from Credit Suisse, but particularly Mr. Clancy's testimony, was pivotal for him. I think his view was, maybe paraphrasing, but he was tending to lean toward Air Products until he got to the supplemental hearing and he heard Clancy's testimony, and that was pivotal for him. How did you deal with that in closing argument? You clearly had an uphill battle, at least with respect to those directors. How did you deal with that?
Well, not successfully, but the way we tried to deal with it is, Mr. Clancy, Mr. D'Annunzio, everybody has their belief. Ultimately, it's the stockholders' company. It's not the directors' company. Going back to Blasius, these aren't, platonic masters. These are people who give advice. They're allowed to give their advice to the stockholders, but ultimately, it's the stockholders' decision. And, they had plenty of time to communicate with the stockholders. They had plenty of time to make their views known. This was not any type of rush situation. This a year and a half on, it's not a Saturday night special at that point. Nobody is being coerced or pressured, no stockholders. They have their choice, and if if Mr. Clancy is persuasive, they're not going to tender their shares.
It seems in the court's opinion that fact, along with the fact that the stock had moved into the hands of arbitrageurs who are perceived to have a short-term outlook as opposed to a long-term outlook for the company, established the reasonable threat, at least that's what the court found, under Unical. That seemed to be a very odd factual finding, an application of the law, and the chancellor seemed to say so in his opinion, kind of teeing this up for an appeal. Do you agree?
Yeah, I think so. And, like I said before, our argument was always, except for the guy who died and, needed to sell stock to pay estate taxes or something like that, the only reason there were arbitrageurs owning as much of the stock as they did is because the so-called long-term stockholders made a decision that they didn't want to be long-term stockholders. They sold.
Once the opinion came out, um, what was the thinking on an appeal? I mean, the company, decided not to appeal and just pulled their offer. Did you have any view, or were you disappointed? Did you want to take the case up?
Yeah, I was disappointed. I wanted to take the case up, but as I said, there was some tension within the company as to whether to go to 70, whether to either stick at 65 or just pull the offer altogether at that point. The compromise, and I knew this before the hearing, was we'll go to 70. We're not going any further. We're not doing an appeal. If we win, we get the company at 70. If we lose, we're moving on. We've been doing this for a long time. It's, sucking the energy out of the company, and we're just going to get on with our business. So I knew before the argument that there would be no appeal. Now, I say that was certainly what the client had communicated. In the back of my mind, depends what it says, right? And you never say never, because, if you had a juicy enough issue where you could say we have a 95% chance of prevailing, I think we certainly would have made the argument, and we would have maybe lobbied for an appeal. But look, I think the client felt that they had lost at the Supreme Court after what they thought was a well-reasoned, favorable opinion. They weren't feeling the love at the Supreme Court, and I think the client's view, like I said, was we've put enough time, effort, and energy into this. We're either going to get the company or we're going to move on.
The chancellor, in his opinion, says, can you just say never? And he says that's not what this opinion says. But a lot of folks seem to indicate, or seem to think, that that's what the case does stand for, that you can say never.
Well, I think you can say never, but you've got to have the record to support it. So if you're going to say never, it helps to have 3 independent directors who say that, your best and final offer isn't good enough. If we had responded to the decision by saying, okay, how about if we offer $85? I guess it wouldn't be never. I mean, I assume at that point, Clancy, D'Annunzio, and the other guy would say, yeah, no, like, now you have to sell. But, obviously all of this is highly judgmental. We look at the appraisal cases, which are valuation cases, and you got one expert saying it's 50 and another expert saying it's 120. The truth is probably somewhere in the middle. But people can make good faith arguments for all kinds of numbers. So I think if you're an incumbent board and you could make a good faith argument for a high number, I think you can, stay with the pill. Now, if somebody is willing to stick around for 2 election cycles and get control of the board, and the board members, unlike the 3 that we elected, exercise their judgment to say that whatever the offer is fair, then it's not a complete, barrier, impenetrable barrier, but the pill is, after Air Products, I think, is pretty potent. A lot of companies, obviously, as you know, there's a lot of activists and a lot of energy on the side of you shouldn't have pills, and if you do have pills, they should be very limited. So there's a whole, for a company, there's a whole political question and strategic question of whether you should have a pill at all, and what that's going to do to your shareholder base, and what effect that's going to have on corporate elections.
One of the things coming out of this decision is kind of a blurring of the lines between what you have to do in order to successfully complete a tender offer versus what you need to do to successfully complete a merger. Because under Delaware law, in the merger context, the board has to approve. In a tender offer, you could go right to the stockholders. The pill is now that barrier in between. Do you see those lines becoming blurred, or are they essentially one and the same after Airgas?
I think for companies that have a pill, they're one and the same. I mean, I think the message from Airgas is, you have to have approval of the board. Now, you can get that approval by, if it's a staggered board, by going through 2 elections. If it's an unstaggered board, by just replacing the board. Obviously, if the new board approves your offer, they can be sued for breach of fiduciary duty if it's too low, and if they're not independent and they're interested and they didn't act with due care, although usually, the 102B7 is going to preclude that one. So, there are certainly limits, but for a company that has a pill, I think you need board approval.
Are there any anecdotes, anything that stands out in your mind behind the scenes that anyone who was following the case or reviewing the case might like to know that they wouldn't necessarily get out of the cold record?
I think we've touched on most of them. I mean, obviously, the inadvertent production of the reserve price was a big moment in the case. The 2-tier confidentiality and Cravath not being able to see those documents was a big turning point in the case. And then obviously the tension within Air Products about how good a deal this was and whether it's something that can be pursued. I think if you look at the facts, knowing that was going on, you sort of say, aha, that's why this unfolded the way it did.
Do you think that you may have been had a better shot of being successful if the case had been on an expedited track?
No, I actually don't think so. Part of for any pill case, I mean, I think everybody agrees. You can agree or disagree with the Air Products decision and whether you should be able to leave a pill in place forever if you think the price is inadequate. Reasonable minds can differ about that. I don't think reasonable minds can differ that it's perfectly fine to have a pill in place for 6 months or 8 months so that the company can get its strategy together, communicate with its stockholders, take the steps that are necessary to make sure that when the stockholders decide whether to tender or not, that it's a fully informed decision. And so, I think that the case unfolded on the longer time frame, and part of that was, it wasn't all eggs in the litigation basket. It was, we're going to have a proxy contest, we're going to get people elected, we're going to change the bylaw, we're going to do all those things. It was all designed to signal to the company that, one way or another, we're going to prevail. You ought to cut the best deal you can. Obviously, the strategy didn't work, and I give Mr. McCausland and his team, they had a vision for the company. He knew that business. He had rolled up all those little mom and pop shops, and he was, he really knew the business.
Ken Nachbar, thank you for your time. I really appreciate it.
You're welcome. Thank you.
All right.